Well, welcome to the Act 41 seminar today, talking about the transparency and financial, or actually exam reform bill that was passed earlier this year. Before we get into it, I introduce our moderator and our panelists. Just want to pass on to you that we are developing out a broader webinar series. Our next one is scheduled for February. It's about a new program, a ride-sharing program called Toro, and its insurance implications. In January, we have another upcoming seminar on business transactions. So it deals with merger and acquisitions activities. So if you're interested in that, take a look at our events section. The other thing I want to point out is that during this seminar, there is an opportunity for you to ask questions via the chat function in the Q&A function that you'll find in the bottom of your screen. And we do have some expert question and answer people monitoring that. So at any time throughout this broadcast, feel free to do that. With that, Joel, I want to turn it over to you. And since you're going to be serving as our moderator, and it's all yours.
Thank you, Ron. I'm Joel Hopkins from Saul, Ewing, Arnstein, and Lehr. I'm a partner here in the insurance practice group. As you can see, I have a great panel here with me. Fran Gallagher, who is the president of PAMIC and a real driving force behind Act 41. We have Fran Roggenbaum, who is my partner here at Saul, Ewing, Arnstein, and Lehr. She's in the insurance practice group and also involved in the process here. And to my immediate right, we have Joe Dimmemo, Deputy Insurance Commissioner for Corporate and Financial Regulation. And Joe is the guy who actually gets to put all of this into effect and make it all work. So we have a real good range of people on the panel. We also have Steve Davis from Stradley Ronan, who is behind the scenes but helping us with questions and kind of fielding through the process. So thank you all very much. I think, Ron, it probably makes the most sense to start with you because you were, and PAMIC was, the driving force behind this. Why don't you give us a little bit of background on how we got to Act 41? Where were we before Act 41? What really was the impetus for it?
Okay, well, this is actually great timing because we're almost on the 10th year anniversary of the Great Recession of 2008. That actually broke, I guess, in September of 2008. And the big issue back then was the impact on the state budgets because of tax revenues coming in and so on. So, for example, in Pennsylvania, we had seen about a third of the department's budget cut simply because of the implications of the Great Recession. Well, that challenged the regulators, and at the time I was a regulator there, on how are we going to continue to do our jobs. So we looked at the tools that were available to us, and in the exam law more specifically, it does provide the authority for the department to use outside consultants to do some of the work. So what had happened is simply because of the shift in the budget by dropping a third, we started to have to use outside consultants on a more regular basis. Now, there had been a time where the consultants were used more on a specialized need. So if there was a unique need for an actuary or some type of an attorney, they would do that. But it became, that by exception practice became the norm. Now, that's kind of how we really got to where we are now. But even prior to that, I have materials that date back to the early 80s with companies complaining about their exam costs. So I think it's just a natural tendency for companies to look at what the agency is doing, what it's costing them, and saying, hey, this is too much money, and so forth. So what had happened as a result is that we tried to look for solutions. And over the years, it was a very difficult situation fiscally for the department. It was 4 or 5 years where the department's budget was cut dramatically. And it's only been in the last 4 or 5 years where they've actually seen some increases in their operating budget. So we started looking for other solutions. Part of that was, well, if the department can't make an argument that they're not being funded well enough, maybe we need to get better visibility to what the real impact is on the industry. So that was part of what we thought about is, okay, having to now actually show the companies that the department's using to do some of their regulatory work and the amount of money that those companies have billed for the work that they have done. So that was one part of it. And then during the process of negotiation, another state, Minnesota, actually passed a similar type of bill that put a little bit more substance behind the actual exam process. Yes, we know what the exam had to cover, but this was kind of the administration of the exam, and that there was never really a good process for that. So we stole shamelessly from the Minnesota bill. Pennsylvania did as much as we can. We also had our partners at the Insurance Federation jump in on this issue as well, and ultimately we got to a bill that we could all agree to. Which ultimately became Act 41.
I noticed the preamble to the act talks about that it's designed to facilitate cooperation, minimize costs, increase efficiency, transparency in the process. Other than the costs, were there any other concerns, anything else that the legislation was really designed to focus on?
So related to the cost are two things. One is the actual rate that companies have to pay. The other is how efficient are these exams being run. And I think most companies that are undergoing exam really didn't know if they had a voice in coming up with how we could be more efficient and more effective in those exams. So in lieu of just, constantly berating the department over this kind of stuff, and Joe Dimmemo, who's sitting to my left, inherited a lot of these things. So he came in with a fresh set of eyes, which I think was a good thing as well, because we were able to talk, with a different perspective about what had happened. But at the end of the day, what we saw was a realization that there are some ways that we may be able to do these exams more effectively and more efficiently. I think ultimately, in a cooperative spirit, the department saw the same thing, because remember, they've been the receivers of this criticism for many, many years. So having a process in place that everybody understood, can work through, I think, just helps the process move forward and become more efficient.
What did it take to get everything put into place? Who did you work with? Who did you get to sponsor? How did you get the process?
Originally, we started talking directly with the insurance department about this, and it's been no secret that we've been sharing the concerns that the industry has had with the exam process and how the exams have been going up, the cost of the exams. And there's a lot of reasons why the exams costs went up. We moved away from kind of the traditional auditing of the numbers to the enterprise risk management approach. And then the Great Recession hits. And so you have all of these things impacting the cost of exams at the same time. We also started talking to our legislators more effectively and saying, hey, something has to happen here. There's a hidden cost of regulation that you should be aware of. And they wanted to know more about it. And they also wanted to see if there were any workable solutions. So once again, in a very open and cooperative fashion, we worked with the members of the House and Senate insurance committees, worked with the department on this, and then our other brethren in the trade association business, and ultimately came away with a bill that was unanimously passed in both the House and the Senate and signed by the governor relatively quickly. And I know Joe's probably going to talk a little bit about the successes later on, but there are some successes that have been a positive outcome of this bill as well.
Well, and before we kind of dig into the heart of it, from your members' perspective, from the insurer community, what are you hearing? What's kind of the feedback?
Well, there's, because they do about 270 exams a year, so only about 50 exams 270 domestic companies. You do about 50 exams a year. We're starting to see the exams come up that under this new law. And the good news is that we're hearing some very positive results. The communication between exam managers and the companies are better. There's more efficiencies that they're seeing. For example, one of the things, and I don't know if I shared this with Joe during another conversation, is one of my companies mentioned to me that their exam actually took over 100 hours less this time than it did in previous exams. That's pretty substantial, and a lot of it had to do with, I think, better automation on everybody's part, knowing what the process is, having a say earlier on in the process, where you can look for efficiencies ahead of time.
Good. Well, it's good to hear that at the end, but so I think probably this is the point, Fran, where we should jump to you and maybe start with getting a little bit of an understanding as to actually what's in here. So the first thing I'd like to ask you about is, I know Act 41 requires a scheduling conference between the department and the company being examined. Can you tell us how that works and what's required?
Yes, but I'm going to take it in a little bit of a different order from what I think you're going to ask the questions, because I think that there are three sections of the law that follow very, very nicely and that need to be understood in context. And I think I have to reiterate something that Ron said, is that this law is about transparency in the process of scheduling and pricing the costs of the exam to the company, but it does not change what needs to be looked at in the exam itself. So that's very, very important to keep in mind. So it's still the risk-focused exam process, which is much, much, much more detailed and digs up into a lot more things than exams prior to the financial crisis. But the process that's set forth now in Act 41, and I'm borrowing this from what Joe shared with me as to what the department has communicated among itself as to what it's intended to do and what the impact is on examiners and the impact is on companies. And so I'm going to read this because it comes from an insurance department document. What is the impact on examiners? More complete planning and budgeting process, including budget monitoring. More accountability to account for time spent on an exam. What's the impact for insurers undergoing an exam? Earlier and more complete disclosure of exam costs. Opportunity for discussion on exam costs with department examiners, and better understanding of the exam process. And I think that as I go through what the law says, and then as Joe talks about how things actually are occurring, some of which the department started even before Act 41 was law, it demonstrates how those things are coming to be. First of all, there's three things, three process items that are addressed: scheduling, budgeting, and billing. And then there's a public disclosure, which I will allow you, Joel, to ask me the question on that one.
Well, let's do that. Let's start with,
Okay.
against that backdrop, Fran, and thank you. Let's start with the scheduling. What's changed, what's in the law, and really what can carriers start to expect from Act 41 in that regard?
Okay, I don't think that having a scheduling conference is anything new, but the law now specifies that there will be a scheduling conference prior to there being any field work, and the law specifies some things that have always been done. During the scheduling conference, there must be a discussion on the purpose and the scope of the exam, the estimated cost for the exam, and the types of information that the company will be asked to produce. But here are the two new important pieces that are in the law. Also to be discussed is the most efficient means of conducting the examination and any alternative approaches in conducting the exam that would be more convenient, less burdensome, or less expensive for the company while still providing an effective examination by the department. And that's an area where I think that insurers need to think about that in advance once they receive the exam warrant, and they'll know what types of things the department's looking for. So companies need to be able and willing to perhaps provide some information to the department.
Are you saying, Fran, that really has to be a two-way street? It can't just be, hey, department, tell us how you're going to do this better. It really involves the insurers saying, here's how we think we can do this. Is it more of a discussion?
I think it can be more effective if insurers come in with ideas for efficiency.
And Joe might be chomping at the bit here, so if there is something you want, but I'm going to ask you the same question later, but if there's something you're thinking now, feel free to throw it out.
No, I think what Fran said is right, but implementing the way the exam process works is a little bit different. From the perspective that, like Ron said, we average about 55 exams a year, financial exams. We decide how we're going to do those, whether it's internal staff or it's external staff. We send out exam warrants, which starts the process for the company saying we're doing an exam. We have a listing of information that we typically request for them to begin to prepare, to gather, and submit to us. And that's before we even get there. That's before we do the scheduling conference. Also, as part of the exam process, our folks, our examiners who are assigned to that particular exam, have to look at the analysis files. We have separate parts of the insurance department. We have analysis, who looks at the annual and quarterly financial statements. They have notes, they have files, they have information on the company. We have the examiners who actually do go out to the field and do the exam process. Before the examiners go out, they take a peek at the analysis files. Everything that the analyst have done for the last couple of years. And they even go back and take a look at the prior exam, because we have a teammate file that includes all that information. We know what it cost the last time. That's our first estimate in regards to what we expect the exam to cost going forward. We have the last cost associated with the exam that was performed 5 years ago. We see and look at the information that's supplied in regards to any changes to the company that were incorporated that were not there the last time. We have estimates of hours in the teammate file in regards to how much time was spent before. So we have a starting place in regards to what we anticipate is going to happen going forward, unless it's a brand new company. But if it's a company that's been in existence, and this is at least the second time around, we have a pretty good feel for what we're going to be looking at and what we can expect going forward. And we can make decisions based on the complexity of the company, whether we can do it internally or we need some additional support from the outside. We also know, because we have a couple examiner people who are trained on the actuarial side to look at the reserve analysis and determine whether we need any outside support in that regard too. So not only do we have charges that are going to be coming forth from internal examiners, from potential outside third parties who are working for the department, but we also have specialties that we have to take a look at. And depending on how we perceive the need for additional expertise in regards to reserving, or whether it's cybersecurity or something else, we'll make those decisions up front before we actually get to the company. But once the initial review we're starting to charge once we send out the exam warrant.
So all those efforts are part of the initial cost.
All those, yeah, and they would have, when we started for the entrance conference or the initial sit down with a company, we go through everything we did so far. We're going to estimate what the cost of the exam is probably going to be. We're going to tell them that the first 30 days we're going to do a deep view of what the company looks like now, what we expect to do in terms of our activities going forward, and present them with a budget within 30 days that they can take a look at, have questions about, request additional information on. We're going to show them what it's going to cost, by individual, by hour, and we're also going to show them the travel, which is a big portion.
Before we talk to the budget, and because I want to jump back for Fran to give us a little background on the budget part, the process, the pre-scheduling conference process that you just talked about, has that changed at all with Act 41? Has the department looked at that, in the spirit of Act 41 and said we might be able to find some efficiencies by doing anything different, or is it really the process that was in place before?
The general process is dictated by the exam manual, and there was always an entrance conference that existed within the exam process, whether it was market conduct or whether it was the financial exam. That doesn't change and didn't change. What changes mostly, from my perspective, is that there's a budget process that we have to go through.
Well, then with that, I'll interrupt you and I'll take it back to Fran and let
Okay.
Fran kind of walk us through a little bit of the budget estimate and revision provisions that are in Act 41.
Well, the fact that Joe stole about 90% of what Act 41 says that I was going to cover, I will repeat it very, very briefly with an ending part. What Act 41 says is no more than 30 days after the scheduling process or conference, there'll be another meeting where there will be a written budget estimate presented to the company being examined that will identify individuals or firms performing the exam and their daily or hourly rates, provide an estimate of travel, lodging, meal, and other administrative costs, and then estimate the length of time to conduct the on-site or off-site exam activities. Thereafter, within 15 days of presenting the budget estimate, then there'll be another discussion regarding the most effective and efficient means of conducting the exam, where then there can be adjustments made to the budget, adjustments made to the time periods. So Joe kind of covered all of that, but then there's this third piece, which is the most interesting piece, and I think which probably is most challenging to the department. And this is only it occurs under two circumstances. Act 41 requires the department to hold another scheduling conference and provide a revised budget under two circumstances. One is if the department determines that the cost of the exam will exceed the budget estimate by more than 10%, or if there's a material change in circumstance. So the department has to come back and have another meeting if either of those circumstances occur.
Well, one of the things you talked about were, with the budget estimate is revisions. So I think, Joe, it's fair to come back and kind of ask you if you can walk us through how does that process work? Can a carrier sit down and say, boy, I think you guys have really overshot the mark on this one. Let's pull that down a little bit. Is there, do you anticipate more back and forth going forward? But what's really the practical side?
I don't think it's a negotiation. I do think it's a discussion. I think that, mostly what we do is based on what we're required to do under the exam law and for accreditation purposes. And the exam manual is kind of detailed. And the only question you really have is there an easier or a better way to do it, a more efficient way to accomplish what we need to do? And just give me an example. Maybe there's an internal audit function at the company, and there's something that we want to review that's already been done by the internal audit function. Maybe that's something we can lean on and borrow and look at and eliminate the need to have somebody from the outside take another look at that. That would be an efficiency that is generated by the discussion that we have with the company. The discussion in regards to travel is a big item. A lot of our folks live in Western Pennsylvania. A lot of our companies are in Eastern Pennsylvania. So when they travel to do an exam in Philadelphia, it's an overnight stay. We're looking at ways to cut down on the travel, to be able to work, get information and work outside of the company itself, do it at home or in the office where they're located. Travel is a big area that we're trying to look at to reduce the overall cost, which is going to be beneficial not only for the department but also the company itself. So any kind of discussion that we can have, say that we need to do something, we explain our next process. The company has the ability to say, well, we just looked at that and we may have some information that's available that you didn't ask for initially. But we have that and we can provide it to you, and maybe that can help support what you need to do and hopefully reduce the number of hours. Anything like that is going to be taken into account. And, you know, I think that's beneficial again for both of us. We're, you know, the goal is not to charge as much as we can. The goal is to accomplish what we need to accomplish in accordance with the manual and the accreditation requirements, and to provide some comfort to the policyholders that regulators taking a peek at this and they should feel comfortable buying insurance.
I think historically there has been a perception, whether it's the reality or not, I don't know, but there has been a perception that third parties who are doing some of this work through the examinations might not be kind of reined in as much as they could be or should be. So can you talk a little bit about where efficiencies can be found there? Is it through an RFP process where you make sure you're getting appropriate number and hourly rates? Is there any sort of oversight the department can provide with respect to those vendors? Where might some efficiencies be found there?
The selection process for an outside vendor is generally we're looking at a return vendor. If they did it the first time, there's going to be more efficiencies the second time around, the next 5 years. And that's one of the first things we look for. And everybody welcomes that, because when you change vendors, it's a new teaching experience for the new vendor coming in. And the companies has to spend time and effort to just give them background in regards to that particular company. So first of all, we're trying to look at who we used before, if we use an outside vendor, to have some familiarity and have the same people involved in the next exam. And that's probably the biggest savings that's going to be generated if we're able to do that. We don't go through a bidding process. We won't have the time and availability to do that. We would need a year out in order to get all 50 exams scheduled and evaluated for that period of time. What we do is we have a list of approved vendors. We go through that every 3 years. That we have an evaluation, like a RFQ, request for qualifications, that they have to submit. They have to submit and guarantee the rates for a 3-year period. We go through the list. We try to, if we need an outside firm to help support our efforts, we look for the one that has the most experience in that particular line of business that the company's involved in. We try to do it that way, and once we start, we try to continue with that vendor for the future if we can get that accommodated. And before we start, they have to prepare a budget. The budget has to be reviewed by the director of examinations. There is some negotiation between us and them in regards to what they're going to do and how much they're going to.
That includes the rates?
Yeah. Well, the rates come in through when we do the request for qualifications. The rates are guaranteed for that 3-year period. So when they come in, really what we're talking about is a number of hours. The rates are in the form we've already approved. The hours are the amount of time that they're going to spend doing this specific function. And we can negotiate that, and we do reduce that. And nothing starts until the director approves that. Once they approve that, and I don't know how it was done in the past, to be honest with you, but since I've been here in the last 3 years, we send that to the company to look at. That's going to be their cost for their outside vendor going forward. So they have that as a budget in relation to what the outside vendor is going to cost. We have to add to that, what the internal function is going to be. So that's generally the way it works. And to the extent that they exceed, like Fran said, under the new law, Act 41, if it goes beyond the 10%, we have to go back to the company and say, here's what happened. Didn't meet this guideline for this, the following reasons. We need some additional support here. We found this to be out of line, and we just want to take a closer look at it. We're going to need some additional hours here. We can have that conversation.
So I understand when there may be a material change in the scope of the exam for some reason, but what happens in the situation where you would have, maybe even at the contractor level, you would have that particular contractor or the employee assigned to leave for whatever, How is the cost of that handled on a go-forward basis? Because clearly the company, the insurer, had nothing to do with that.
Right.
How have you been handling that situation?
We have to replace. To the extent we need additional hours, it's either going to be somebody internally, or we're going to have somebody else from the contractor support that audit exam function. We try to keep the outside at the same level. Inside, we're kind of restricted to what we have available at that particular time. But in that particular case, and it's covered under Act, we would have a discussion with the company saying there's been a change here. The person retired, people do retire.
Is that follow-up discussion when you exceeded the 10%? Is that another opportunity to find some more efficiencies, or is it just informational?
Here's what happens. Once we begin the exam, we have biweekly discussions with the company in regards to the progress being made. It's not like we get to the end and here it is. We're ready to go. And by the way, we were 15% in excess of it. One of the things about Act 41 is we got to track that. The manager's responsibility is to track that, and they got to keep up, because we're not going to. And I talk to the folks all the time about this. We can't get to a point where we're 20% over and we don't know it, and we already missed our requirement to meet the 10%. And so we got to track it. We sit down with a company every 2 weeks, give them the progress. They get to ask questions. It's usually they designate somebody within the company to be the contact person with the exam team. Generally, it's the CFO or one of the accounting persons there at the company. And we have these discussions. And actually, I think that the communication between the examiners and the company is it's pretty strong.
So, Joe, from what you're saying, there's a sea change in the fact that the exam managers now have to not just worry about meeting the accreditation standards, making sure they
got to meet the budget.
Right now, which is the big difference here. And I'm sure that's a cultural change within the department. How have you trained or educated your exam managers to kind of take on that newer role?
Each year we have what is labeled Oktoberfest. You probably went to it
once or twice,
and you probably spoke it. And last year we brought in some of our outside vendors to provide overview and to discuss budgeting and how they incorporate it into the scheduling and estimate of hours and all those kind of things. So that was the impetus of it. We're brand new at this, so we're not going to be experts initially, but I think it's going to grow on us. And once people adopt it and focus on it, I think it's going to be beneficial in terms of trying, or at least once you focus on the budget, I think ultimately the costs are going to be contained. If you don't have that budget, and that's why I agreed with it right from the start. When you approached this and said, we want to get information about what it's costing the industry, and we want transparency, and we want a report prepared annually. And I had no issues with that at all. Whatever we do is public information, should be out there. Well, and the next issue was then, the cost of the exams. And the Minnesota legislation talked about budgets. We should have budgets. People should know what it's going to cost them for the exam. And they should know before the end of the exam.
Yeah, it lends to the transparency.
And
I want to shift, and I want to ask you what personally I found the most interesting word in Act 41, Act words, alternative approaches. When the Act talks about exploring the possibility for alternative approaches to the exam process, you talked a little bit about how the manual dictates certain things be done, and we certainly know there's history there. But I think a couple of our clients are very interested to know, does this mean, hey, I'm a real small company and maybe we can do it a little bit different? Maybe we don't have to follow that process that we went through before. Maybe we don't have to do what the big carriers do. Is there anything the department's been looking at as an alternative approach to the process?
The process is the process. And if it's a multi-state company, it's an accreditation requirement. For some of the smaller ones, and this was done by my predecessor, Steve Johnson, did this. He established a small company review, which, it just concentrates the focus on certain specific areas with the hopes that it was going to reduce the overall time spent by the exam team in reviewing that company. But there's probably, out of the 265 companies that we have, that probably only applies to maybe 35. So the rest of them are going to go through the full examination process. The alternatives, it's not, from my perspective, we look at it from an efficiency standpoint. We look at the travel. Can we cut down on the travel? A person who can perform the same review in their office in Pittsburgh or Philadelphia without being on site, incurring overnight reimbursement, hotel costs, travel expense to and for. Also, if there's information available at the company that will cover a review that we have to do that maybe we were not aware of, that somebody's already looked at it in detail, it's been reviewed and it's professionally done, that we can use that to supplement what we need to do in regards to the exam process. Obviously, the company can come up with, they know what we do. If it's a return event, if it's the second 5 years, and I think most of them at this point we're at least 2 into it, they know generally what we're going to do, and we have that discussion at the initial conference. If they can show us ways to reduce the hours, we're willing to have that discussion.
Can I follow up on your question about that section, alternative review? So the law went into effect in July, if I recall.
It did.
So approximately how many exams have you called since that law actually went into effect?
Well, we probably initiated the exam warrants for all of them that have to be done this year. We have completed maybe about 8 of those.
Okay.
Most of them smaller ones. Each one of those has a reduction in the number of hours. What you're not going to see, what the folks probably won't see, is a big difference in the cost from what they paid before.
Mm-hmm.
And it's generally related to just inflation over the 5-year period. What they paid per hour 5 years ago is not what they pay today. If you look at the Commonwealth, the way you receive increases, or some people receive increases, is that it's generally about 3% a year. So over a 5-year period, you're maybe talking about 15% increase. Even if you kept the hours the same, the cost is going to be more. But we've seen, in some cases, considerable reductions in the number of hours spent on the exam. Second, third time around, more efficiencies in that regard. But I think having a budget is going to focus people on maintaining and keeping.
But on the alternative approaches, have you actually received any requests from any of the companies, whether they're my members or just other insurers at this point? Because it's a two-way street.
It is.
They know how their operations work.
Yep.
And you know what you need to examine. So I guess we need to challenge our members as well to think about alternative ways that could either make it faster, less expensive, more effective.
I agree.
All those things.
I sat in probably maybe 3 or 4 entrance conferences under the new law. There's not many questions that we get. from companies in regards to what we're presenting.
Well, it is new. It is new. So
It is.
that level of trust and confidence
I
needs
agree.
to be built.
Well, Ron, I think this process is a good way for your members to hear that and take that to heart and say, it's up to us. This is a two-way street. We need to be involved. I do want to hit on a couple things, Fran, because we jumped over the billing invoices in the annual report. Can you tell us very quickly what's changed with respect to billing invoices? And then maybe we can kind of finish up before we get to questions and talk about the annual
I'll go
report.
very, very quickly. Expect invoices from third-party consultants to be very detailed. They must be itemized, detailed description of charges on a quarterly hour basis, and they must include applicable billing rates and a per-charge description of related travel or other expenses. Department invoices do not need to show that, but they need to say, tell companies how they can get that information. The law now requires that invoices must be submitted to a company on a monthly basis, no later than 60 days from the date on which the billed activity was performed. Provide a due date no fewer than 30 days after the bill is submitted. And they must contain an explanation of the invoicing process and the procedure for resolving billing disputes. So some of that's different. I think the biggest difference here will be in the detail of the third-party consultants' invoices. The last piece, my last piece, which is not part of the process, but I think is very interesting, and what Joe said the department absolutely supported, is the public disclosure. There's already been one, the annual examination and analysis report that must be published annually by the department. The first one is already posted on the department's website. It was posted on July 30th for the fiscal year of 7/1/2017 to 6/30/2018. And what it must indicate are amounts billed by third-party vendors, identifying the third-party vendors, as well as the total amount that each third-party vendor received. It must also talk about some analysis on efficiencies. But I think that disclosure is a big disclosure that at least Ron has indicated that companies have asked for. How much are companies in total being charged for third-party vendors? Now, interestingly, both the billing process that I just described, as well as this annual report, is not including, those provisions don't just apply to financial and market conduct exams, but they also apply to other laws where third-party vendors can be retained by the department at the company's cost for looking at such things as conversions, ORSA reports for those companies that have to do ORSA reports, risk-based capital evaluations, filings under the Insurance Holding Companies Act, and the law was clever enough to include and all future laws that would have similar provisions. So be prepared for 2020 when the first corporate governance annual disclosure filings are examined by the department.
Now, can I ask a question? So at first Act 41 report, is relatively thin this year. Could you explain, why it doesn't show necessarily all of the activities and all of the vendors that have been used throughout the prior fiscal year?
Yeah, we read the law as not taking effect until July of this year.
Okay.
And it applied to any exam that had begun after that contract. I think it was July 22nd. Actually, there's only 3 vendors on the list for this year, and they all related to financial analysis activity and not related to the exam process. We took a peek at some of the ORSAs that we, the ORSAs are very complicated, and we needed initial review by an outside vendor that helps support us in that area. We have some of the Form A acquisition that we occasionally need support for. And we have some other troubled companies that potentially need some support, and we get outside vendors. They will all be listed. They will all have the amounts that they have been paid for the year. Obviously, I think as we go along, there may be additional requests for information in that regard. We set it up some first. As we go forward, it may be amended to accommodate some other needs that folks have in regards to the use they want for that. But it's going to be complete. It's going to be complete, and it should show essentially the cost of regulation.
And we're gonna try and stop here and take a couple questions. But one thing I know, the one section talks about the department is to kind of measure the effectiveness. How is the department going to do that? How is it going to say, here's what Act 41 has done to improve? Is it literally just looking at cost year over year, cost reduction, or is there a bigger scope to measuring how effective it's been?
Yeah, the effectiveness from my perspective is whether we accomplished the budgeting process timely, whether we communicated it to the company and they had input into it, whether it's seeing any results in the bottom line. That's not going to be able to be measured for several times now. Once and done is not going to give it unless we compare it to the last one, which may or may not be the reason why you save the cost. But we're going to look at, in regards to timely filing the report, the effectiveness of that. The efficiency is not going to come out until we actually are able to measure the cost. And we should be able to see on a gross basis for all the vendors and the internal staff that we use going forward, what it's costing from year to year, and whether we see any decline in that or increases or some kind of measurement there. And not only for the internal cost, but the exams themselves from company to company.
Good. Steve, any questions other than?
Yeah, we have a few here. One is, does this apply to market conduct at all? Market conduct exams?
Yes.
The answer is absolutely yes. The exam law in Pennsylvania, we only have one law dealing with exams, and it covers both market conduct as well as financial exams.
You talked a little bit about the small company list process. Do you have any company size parameters for determining whether outside vendors will be used as opposed to internal, or is that what you were referring to?
The small company list, we don't use outside. We use internal folks. For smaller companies, we're able to gauge the complexity of it and understand that we can use internal folks that will reduce the overall cost for these companies.
And above that, there's
recognizing that we got a certain amount of companies to do in a year, and things change occasionally, and we got to do what we got to do.
So are you hedging your comments right now?
I want to make full disclosure.
You mentioned you're eliminating the need for travel by allowing remote information sharing and the like. Is that also applicable to your outside vendors? Are you trying to corral them to do things?
And we're not eliminating travel. What we're doing is reducing it. We're attempting to reduce it, the cost of travel, not only internal staff, but outside consultants that we use. Again, they don't always line up in regards to geography. Whether the firm is a Pennsylvania firm or outside of Pennsylvania, usually you're going to see the firm there at the entrance conference to introduce and make sure they understand who comprises the team. But a lot of the vendor work is done away from the company site itself, which again is a reduction in overall travel.
Well, I have a question for you. This actually deals sort of on a future look basis. So we have the new corporate governance annual disclosure law that technically the first report will be due by June of 2020.
Yep.
Do you anticipate, because of that annual disclosure, some type of impact on the exam process? Because it's very qualitative in nature, more along the focus of a risk management exam. Do you see some synergies there that may also lead to some efficiencies in the exam process?
It's another report that the examiners are going to take a deeper look at when we do the exam process. It's like the ORSIS. The ORSIS is done by our analysis function, and it's done annually, the review. We do a deeper dive when we go out to the company, do the exam process, and actually look and see how it's been implemented and how it's operating. And we would do the same with the corporate governance annual disclosure. I do see some synergies there. You know, they're not separate functions. You're really talking about the operation of the company and how it impacts the risks that they are writing and what they're doing. So I think from that perspective, you know, there's going to be some efficiencies in regards to looking at those together, as opposed to separately and doing something separate outside of the regular function.
I was just going to ask if that is now very few companies have to do the ORSIS, but everyone
we have 18.
Yeah, everyone has to do the corporate governance annual disclosure. Yep. So is there support for the concept that the more and better you disclose things on the corporate governance annual disclosure filing, that may lessen what we the department need to do deep dives on in the exam process?
I'm a little hesitant about answering.
It can't hurt. It can't hurt the process.
Okay. Only from perspective that, you know, I think a lot of the folks are going to use the template.
Right.
Yeah.
And the template doesn't have a whole lot of information that you're going to provide. I think it's going to have the basics and it's going to comply with what we need. But, you know, the bigger companies provide a lot of information. Right. They're more detailed. And I think that is beneficial.
Okay. Yeah, because that's what I was thinking. Is this a way that if you have, I know that it costs less to prepare the template that the department's going to post, but if you're looking at ways in saving money on the exam, and you're the one controlling the cost of handling the CGAD, then maybe do a more thorough job on the CGAD.
That should be helpful.
Steve?
Yeah, this is a good technical question, Joe. When you guys hire outside actuarial firms to do reserve studies, have you typically, or have you considered doing that on a fixed fee basis as opposed to hourly? Because the questioner points out that that's typically how companies on the outside price those engagements, is on a fixed fee basis. Is that something the department has done, and if not, would it consider doing that?
Yeah, that would be another process that we would have to go through to see how best to do that. You know, we talked about probably over the last 2 years, is there an opportunity to even bid out all the exam processes in terms of when we need outside vendors to do that. The time you need from start to finish to do that is probably 3 to 6 months. So you need a year in advance to even begin that process, so you know what you're going to have when you need it. You know, and that's the difficulty in the Commonwealth system. It just is. Procurement laws are difficult, and I'm not saying it's out of the question. There may be an opportunity, and maybe that's something we can look at on a trial basis to look at an actuarial analysis for a specific company, get various vendors to bid on it, select the vendor that we think is going to provide the best service, and have that be the bottom line in regards. But when we do bids, or when we select the vendor, we do get an estimate, and those estimates generally don't vary. If it exceeds 10%, the budget, we have some explaining.
That's helpful. And this maybe is to everybody. Do you believe that this disclosure process will ultimately have any impact on getting the General Assembly or the governor to consider dedicating more resources for the department ultimately?
Yeah,
You want me? Let me try. The philosophy behind the bill was to actually expose to our public policymakers what the true cost of regulation is in Pennsylvania. Prior to this report, there was no accounting for that because there were no government contracts. If it was under a government contract, you'd be able to go to the Department of Treasury and find all that information out. So I think it's a little premature to be actually able to say it's going to have a positive effect, but it definitely won't have a negative effect. I think it will make it easier over time for the industry and or the department to say, okay, this is the true cost of regulation, and these are the resources we're going to need. When you also tie it, if you think about it, into how the IROF works, the Insurance Regulatory and Oversight Fund, as you start approaching that 50% limit on how much money you can get, we now can go and say to the General Assembly with good data, not just anecdotal data, saying, hey, there needs to be a change here. Now, whether or not our public policymakers agree with us or not, but at least we have the data to do it. And that was the thinking behind this transparency the whole time, never to shame the department or anything like that. It was simply to be able to make these arguments. Now, I don't know how you feel about it, but that's how we thought about it from the very beginning.
I think it's going to be another data point to look at in regards to the cost of regulation for insurance in Pennsylvania. Just keep in mind that, Pennsylvania is not unique here. This happens all across the country in various states, and that most states, have a internal staff, a core staff that is the basis for the exam process, but they need to supplement it with outside vendors. The difficulty is when you get a huge company, an international company, and you expect to do that exam with internal folks. That's a challenge. And not to say we don't have qualified people, we do. It's just that when you have to staff that kind of exam, you're generally always going to need some outside support for that. Sure. It's just the way it is.
I see we're about out of time. So with that, and I think we've taken all the questions, I'd like to thank everybody. I have a closing remark because I got the advantage of listening to the three of you talk. And my closing thought for the carriers is this: be prepared to show up and be active in the process. I think Joe had pointed out a lot of the carriers sit there at the meetings and take in the information. But to the extent you can find any opportunities for efficiencies, you can find any opportunities for alternative means, be ready to discuss them with the department and see if there's anything that can be done to really make the exam process as painless as possible. Any other closing thoughts?
Yeah, and before we sign off, this webinar will be posted on the PAMIC Live YouTube site. We will also email the link to all of the participants today. I believe, Joe, you also provided us an article that appeared in the Insurance Department's Insights newsletter back in April. We'll put that as part of the package as well. It was done early in the process, so
it was done. It's actually April this year,
right? So, but the law didn't go into effect at that point, right? So it's kind of a precursor to what actually happened. So we'll make that available to you as well.
Thank you, everybody.